The Supreme Court has asked the DoT Secretary to file an affidavit on the dues to be paid by users of shared spectrum. He is also supposed to file a reply on past dues and the dates of grant and transfer of licenses, while the top court has deferred the hearing in the AGR case for the 24th of August. The court asked different telecom companies that suppose 23% of RCom's spectrum was being used by Reliance Jio, then what was the amount which was supposed to be paid by Reliance Jio? Also, the court asked if AGR dues have been paid by spectrum users as per the top court orders. Videocon Telecom's resolution professional informed the top court that their AGR dues were around 1,376 crores. However, the top court made it clear that once there is a transfer of spectrum, it's either Videocon or Bharti Airtel's liability, and that is something which is to be decided by the top court. While Videocon's resolution professional reiterated that DoT had not raised any demand of AGR from them, they also said that the waterfall mechanism and IBC will apply to all government debts as per former top court verdicts and as per the Insolvency and Bankruptcy Code. Bharti Airtel and Reliance Jio also told the top court that DoT had not raised any further AGR demands from these telecom companies. But the top court was insistent in stating that as per trading guidelines, past dues need to be paid before any transfer of spectrum, and if Videocon does not pay, Bharti Airtel will have to pay for its AGR dues. While the total AGR dues of Etisalat currently stand at 82.46 crores, this was something which was informed to the top court by the official liquidator of the former telecom company. Appearing for the COC of Reliance Communications, Harish Salve told the court that DoT had raised a demand on RCom and had contested its resolution plan in NCLT, claiming that spectrum cannot be traded. However, Harish Salve submitted that if spectrum is not traded, it will go back to the government and the government will not get any dues. He also stated that the right to use spectrum is a valuable right written in balance sheets. This view was also echoed by senior lawyer Kapil Sibal, arguing for Bharti Airtel, who said that no one can take possession of an airwave or a frequency, and spectrum is the right to use airwaves, and no property right rests for spectrum even with the government. However, Kapil Sibal reiterated that the most valuable asset available with telecom companies is spectrum, and if banks cannot deal with spectrum, they will stop lending to the telecom sector, asking the top court to allow telecom companies to treat spectrum as an asset in order to ensure profitability within the telecom sector and to ensure that banks continue lending to telecom companies. The hearing in this case will continue on Monday. Also, what remains to be seen is the top court verdict, which is awaited on the timeline of payment of AGR dues, which the telecom companies are yet to pay to the DoT, a verdict eagerly awaited by the telecom and the banking sector.